Welcome. The video you are about to see is taken from real-life traffic court experiences. The information presented in this video, I believe to be legally accurate, should not be construed to be legal advice. What you're about to see is a consolidation of several court appearances into one for purposes of this video. The legal references and court citations are real and shows how the courts are running a massive racketeering operation. I hope you enjoy the video.
The court calls Edward Allen Brotherton. You're charged with violating California Vehicle Code Section 4008(1), driving on expired registration, 16,028 driving with no proof of insurance. How do you plead?
Your Honor, I'm here by special appearance. I have a question about those rights that were explained to us before court went into session.
What is your question?
Well, from what I understand, I'm being charged with an infraction, and according to the video that was shown to us, I don't have a right to court-appointed counsel or jury trial.
That is correct.
Well, I'm very confused, Your Honor, because it's my understanding that rights that are secured by the Constitution are just that, secured by the Constitution. Are you saying that the state legislature decided that two of the rights that are in the Constitution really aren't secured by the Constitution?
Note when it comes to infractions.
But those other ones are secured. So let's say the state legislature decided that the judiciary can no longer support the speedy trial requirement because there's just too much of a backlog of cases, and they made a law to deny the right to a speedy trial as well. Are you saying that you would uphold that law being valid and constitutional if it was ever challenged?
I'm not going to discuss cases that have not happened or issues that are not before this court.
But it is before this court. I'm being told that, on one hand, for infractions that I have rights that are secured by the Constitution, and somehow, on the other hand, it was decided that my right to counsel and jury trial can be taken away at the whim of the legislature, which is completely contrary to what rights secured by the Constitution means.
Mr. Brotherton, the only thing we are going to be discussing today is how do you want to plea. That's all I want to hear right now.
How can I intelligently enter plea when I don't understand my rights as they have been presented to me by this court?
Mr. Brotherton, I cannot make you understand that which you have already chosen not to understand.
Lack of understanding is not a choice, Your Honor. If I ask you what is 2 plus 2 and you answer purple because aliens don't wear hats, is it my problem that I don't understand your nonsensical answer?
If you continue down this path, Mr. Brotherton, you're going to leave me no choice but to enter a plea of not guilty and set the case for trial. If you want to object to the constitutional rights issue, then feel free to do so and you can take it up on appeal. What would you like to do?
I'm going to go ahead and object to this entire proceeding, Your Honor.
Very well, your objection is noted. Now as for the charge against you. How would you like to plea?
Well, I'm still here by special appearance, Your Honor, and it's my understanding that I have a right to know the nature of the action. Isn't that correct?
This is a criminal matter.
Okay, well, in that case, Your Honor, I would like a jury trial.
Mr. Brotherton, we have already gone over this. You don't have a right to a jury trial for an infraction case.
But you just said that this is a criminal case, and under Article 1 Section 16 of the California Constitution, I have a right to a jury trial in all criminal cases. It even says that the right is an inviolate right and shall be secured to all. The California Appellate Court ruled that the limitation of an accused's right to a jury trial of infractions has withstood constitutional attack upon the rationale the legislature did not intend to classify infractions as crimes. This was in the case of People v. Salva 190 Cal App. 3D 935. California Code of Civil Procedure Section 24 reads that actions are of two kinds: criminal and civil. Since it's now known that this is not a criminal action, then it must fall under civil.
Your right to a jury trial is denied. Now how do you want to plead?
It appears we have a serious constitutional problem. Either it's a criminal action and I get a jury trial, or it's not criminal and I don't get a jury trial. Which is it?
It's quasi-criminal.
I'm going to have to object to that too, Your Honor, and I intend to file a motion, so I need to know who the plaintiff is in this case, so that I may timely serve the opposing party in accordance with the law.
The plaintiff in this case is the people and the prosecuting agency is the city attorney's office. You may file your motion with their office. How much time do you need?
Thank you, Your Honor. I'm curious, what is it that you have in front of you that tells you that the people is the plaintiff in this case? The reason I ask is because all I have is a notice to appear and the plaintiff is not indicated on this document.
You'll just have to take my word for it.
I'm sorry, Your Honor, but I don't know you that well. So you will have to do better than that and actually show some proof. California Government Code Sections 100A and B require that all written processes for criminal prosecution shall be in the form and style of the people of the state of California. So rather than take your word for it, how about you telling me what writ or process you have in your possession that conforms to this law, and would indicate an actual plaintiff?
Mr. Brotherton, I'm about to enter a plea of not guilty and set it for trial. You want to file a motion? I'll give you time for that. This is taking far too long and we have lot people to get through. So how much time do you need to file your motion?
Since there is no evidence of an actual plaintiff, I'm going motion to dismiss this case for want of subject matter jurisdiction.
Motion is denied. How much time do you need?
I object, Your Honor.
Your objection is noted and I'm going to go ahead and enter a plea of not guilty.
Objection, Your Honor. The California Rules of the Court 4.100 require that before you can enter a plea of not guilty on my behalf, I must have counsel present. As you well know, my right to court-appointed counsel has been denied and therefore I have no counsel present.
You're representing yourself and therefore I'm going to consider counsel as being present.
Your Honor, I'm not representing myself. I am myself.
For purposes of this court, you're representing yourself.
I object. I also motion to court to withdraw the forced not guilty plea. California Vehicle Section 40,513, B, says that the notice to appear shall constitute a complaint to which the defendant may enter plea. The word may means permissive per Section 15. In other words, because the notice to appear doesn't qualify as a real complaint, the legislature had to write the word may in the law to maintain constitutionality. So the legislature has given a couple of choices to whether or not they wanted to enter plea to that document. I will be more than happy to enter plea if you provide me with a complaint to which I shall enter plea.
Motion is denied. I have the right to enter a plea of not guilty if the defendant refuses to enter one.
Your Honor, you are relying on Section 1024 of the Penal Code, which is a general statute, and the Vehicle Code 40,513, B, is a specific statute and therefore controlling.
I'm done with you. Go see the clerk.
But Your Honor,
I said I'm done. Bailiff, please direct Mr. Brotherton where he can go.